Mr. President, I'm here to speak today in support of the USA Freedom Act, a bill that would restrain the power of government to collect data on phone calls made by average, everyday, ordinary, law-abiding American citizens, 300 million plus Americans, without any suspicion that any one of them is engaged in any kind of criminal activity, any kind of activity involving the collection of foreign intelligence. I appreciate the support that I've received from this bill, and I appreciate the opportunity to work with my distinguished colleague, the senior senator from Vermont. Senator Leahy and I feel passionately about this issue. And although Senator Leahy and I come from different ends of what some would perceive as the political spectrum, although we don't agree on every issue, there are many issues on which we agree. Many issues on which, like this one, we can say that these issues are neither Republican nor Democratic. They're neither liberal nor conservative. They're simply American issues. They're constitutional issues. They're issues that relate to the proper order of government. They're issues that relate to the rule of law itself. The Constitution of the United States protects the American people against unreasonable searches. It does so against a long historical backdrop of government abuse. Over time, our founding fathers came to an understanding that the immense power of government needs to be constrained because those in power will tend to accumulate more power. And in time, they will tend to abuse that power unless that power is carefully cabined, unless it's carefully constrained. America's founding fathers were informed in many respects by what they learned from our previous national government, our London-based national government. They were informed in part by the story of John Wilkes. John Wilkes, not to be confused with John Wilkes Booth, the assassin of Abraham Lincoln. John Wilkes was a member of English Parliament, a member of Parliament who, in 1763, found himself at the receiving end of King George III's justice. You see, in 1763, John Wilkes had published a document known as North Britain No. 45. The North Britain was a weekly circular, a type of news magazine in England, one that, unlike most of the other weeklies in England at the time, was not dedicated to fawning praise of King George III and his ministers. No, this weekly would from time to time criticize the actions of King George III and his ministers. At the time John Wilkes published North Britain No. 45, he became the enemy of the king because he had criticized certain remarks delivered by the king in his address to Parliament. While not openly directly critical of the king himself, he criticized the king's ministers who had prepared the remarks. This, for King George III, was simply too much. This simply could not stand. And so, before long, on Easter Sunday, 1763, John Wilkes found himself arrested. And he found himself subject to an invasive search, a search performed pursuant to a general warrant. One that didn't specify the names of the individuals to be searched, the particular places to be searched, or the particular items subject to that invasive search. It said, basically, in essence, go and find the people responsible for this horrendous publication, North Britain No. 45, and go after them. Search through their papers, get everything you want, everything you need. Now, John Wilkes decided that his rights as an Englishman prevented this type of action, or should have, under the law, prevented this type of action. So he chose to fight this action in court. It took time. John Wilkes spent some time in jail, but he eventually won his freedom. He was subsequently re-elected to multiple terms in Parliament. And because he fought this battle against the administration of King George III, he became something of a folk hero across England. In fact, the number 45, with its association with North Britain number 45, the publication that had gotten him in trouble in the first place. The number 45 became synonymous, not only with John Wilkes, but also with the cause of freedom itself. The number 45 was a symbol of liberty, not only in England, but also in America. People would celebrate by ordering 45 drinks for their 45 closest friends. People would recognize this symbol by writing the number 45 on the walls of taverns and saloons. The number 45 came to represent the triumph of the common citizen against the all-powerful force of an overbearing national government. With the example of John Wilkes in mind, the Founding Fathers were rightly wary of allowing government access to private activities and the communications of citizens. They feared not only that the government could seize their property, but that it could gain access to details about their private lives. It was exactly for this reason that when James Madison began writing what would become the Fourth Amendment in 1789, he used language to make sure that general warrants would not be the norm, and in fact would not be acceptable in our new republic. Ultimately, Congress proposed and the states ratified the Fourth Amendment to the U.S. Constitution, which provides in pertinent part that any search warrants would have to be warrants, quote, particularly describing the place to be searched and the persons or things to be seized, close quote. General warrants are not the norm in America. General warrants are not acceptable in America. They are not compatible with our constitutional system. And yet, today we see a disturbing trend, one that bears some eerie similarities to general warrants, in the sense that you have the NSA collecting information, data, on every phone call that is made in America. If you own a telephone, if you use a telephone, the NSA has records going back 5 years of every number that you've called and every number from which you've received a call. It knows when the call was placed. It knows how long the call lasted. While any one of these data points might itself not inform the government too much about you, researchers using similar data have proven that the government could, if it wanted to, use that same data set, that same database, to discern an awful lot of private information about you. Private information, including things like your religious affiliation, your political affiliation, your level of activity politically, religiously, and otherwise, the condition of your health, what your hobbies, what your interests are. These metadata points, while themselves perhaps not revealing much, in the aggregate, when put in a large database, can reveal a lot about the American people. Now, this database is collected for the purpose of allowing the NSA to check against possible abuses by those who would do us harm, by agents, foreign intelligence agents, spies. But the problem here is that the NSA isn't collecting data solely on numbers that are involved in foreign intelligence activity, nor is it collecting data solely on phone numbers contacted by those numbers suspected to be involved in some type of foreign intelligence activity. They're just collecting all of the data from all of the phone providers. They're putting it in one database and then allowing that database to be searched. Now, this issue was recently challenged in court. It was challenged and recently was the subject of a ruling issued by the United States Court of Appeals for the Second Circuit based in New York. Just a few days ago, just this last Thursday, the Second Circuit concluded that Congress, in enacting the Patriot Act, in enacting Section 215 of the Patriot Act, the provision of the Patriot Act that is claimed to justify this bulk data collection program, the Second Circuit concluded that Section 215 of the Patriot Act does not authorize bulk collection. It does not authorize the NSA to simply issue orders to telephone service providers saying, send us all of your data. The language of the Patriot Act permitted the government to access the records that were, quote, relevant to an authorized investigation, close quote. That's the language from Section 215 that's at issue. Now, the government argued in that case that the term relevant in the context of the NSA's work meant and necessarily included every record regarding every telephone number used by every American. And by interpreting it this way, they tried to basically strip all meaning from the word relevant. Now, if Congress had meant every record, Congress could have said every record. It did not. That is not to say it would have been appropriate for Congress to do so, and had Congress legislated in such broad terms, I suspect there would have been significant concern raised, if not in court, then at least within this chamber and within the House of Representatives. But importantly, Congress did not adopt that statutory language. Congress instead authorized NSA to collect records that are, quote, relevant to an authorized investigation, close quote. The Second Circuit agreed that this is a problem, holding last week that the bulk collection program exceeded the language in the statute, specifically the word relevant. While relevant is a broad standard, it is intended to be a limiting term whose bounds were read out of the statute by a government willing to overreach its bounds. Now, the proper American response to government overreach involves setting clear limits, limits that will allow the people to hold the government accountable. We must not permit this type of collection to continue. Now, while it's true that a single call record reveals relatively little information about you, again, the important thing to remember is that when you aggregate all of this data together, the government can tell a lot about you. I have every confidence and am willing to assume for purposes of this discussion that the hardworking, brave men and women who work at the NSA have our best interests at heart. I'm willing to assume for purposes of this discussion that they're not abusing this database as it stands right now. Some would disagree with me in that assumption, but let's proceed under that assumption that they are law-abiding individuals who are not abusing their access to this database. Who's to say that the NSA will always be inhabited only by such people? Who's to say what the state of affairs might be a year from now, or 2 years, or 5 years, or 10 or 15 years? We know that in time, people tend to abuse these types of government programs. We know from the Church report back in the 1970s that every administration from FDR through Nixon used our nation's intelligence gathering entities to engage in political espionage. It's not a question of if things like this will be abused. It's a question of when they will ultimately be abused. And it's our job as U.S. senators to help protect the American people against excessive risk of this type of abuse. That's why Senator Leahy and I have introduced the USA Freedom Act. It directly addresses the bulk data collection issue while preserving essential intelligence community capabilities. Rather than relying on the government's interpretation of the word relevant, our bill requires that NSA requests would include a specific selection term, a term meant to identify a specific target, and that the NSA would then use the term to limit to the greatest extent reasonably practicable the scope of its requests. We give the government the tools to make targeted requests in a manner that parallels the current practice at the NSA, in many respects, a practice that is currently limited only by presidential preferences. This bill would enable the court to invite pre-cleared privacy experts to help decide how to address novel questions of law, if the court wants any input. The bill also would increase our security in several ways, including by providing emergency authority when a target of surveillance enters the United States to cause serious bodily harm or death, and instituting the changes necessary to come in line with Bush-era nuclear treaties. This bill was negotiated in consultation with House Judiciary Committee, the House Intelligence Committee, and the intelligence community at large. It's supported by the chairman and ranking members of the House Judiciary Committee, of the House Intelligence Committee, and the Director of National Intelligence. It enjoys broad support from industry and from privacy groups. This is a compromise, an important compromise that will enable us to protect Americans' privacy while giving the government the tools it needs to keep us safe. This is a compromise that is expected to pass the House overwhelmingly, and it's a bill that I think we should take up and pass as soon as they have voted. And so I would ask my friend, my colleague, the distinguished senior senator from Vermont, about his insights. My friend from Vermont has served his country well, having served a significant amount of time in the United States Senate. And prior to that time, he served as a prosecutor who had to follow and was subject to the Fourth Amendment. So I would ask you, Senator Leahy, in your experience as a prosecutor and as a United States Senator, what do you see as the major benefits to this legislation and the major pitfalls to the NSA's current practice of bulk data collection?
Mr. President.
The Senator from Vermont.
Mr. President, the distinguished senator from Utah has laid out very well the reasons for the changes proposed in the House and proposed by his and my bill. And he also said something that we should all think about. Just a couple of minutes ago, he said, what about, assuming everybody is following the rules today, but are they going to follow them tomorrow or next year or the year after? And when he mentioned that, he also mentioned my years as a prosecutor. Let me tell you a short story on this. I became one of the officers of the National District Attorneys Association and eventually vice president. A number of us, 4 or 5 of us, had occasion to meet with the then director of the FBI, J. Edgar Hoover. I've thought back to some of the frightening things he said about investigating people because of their political beliefs. You could tell communists because they're all hippies driving Volkswagens, was one of the things he said. Secondly, the New York Times was getting too left in some of their editorials. They're becoming very close to being a communist paper, and he was making plans to investigate it as such. Think of that for a moment. He was thinking because he disagreed, and the New York Times had criticized him editorially, he was thinking I should investigate it as a communist paper. Now, not long thereafter he died, and we found out more and more about the secret files he had on everybody from presidents to members of Congress. What if a J. Edgar Hoover had had the kind of tools that are available today? And that would be my response to the senator from Utah, why I so agree with him that we have to think about not just today, but what might happen in the future. Because for years, Section 215 of the Patriot Act has been used by the NSA to justify the bulk collection of innocent Americans' phone records. And Americans were appropriately outraged when they heard about this massive intrusion into their privacy. But then look what happened last week. A highly respected federal appeals court, the Second Circuit, confirmed what we have known for some time. The NSA's bulk collection of Americans' phone records is unlawful, it's not essential, and it must end. That basically says it all. It's unlawful, it's not essential, it should end. Under the government's interpretation of Section 215, the NSA or FBI can obtain any tangible thing so long as it is, quote, relevant to an authorized investigation. Think for a moment of J. Edgar Hoover. And I do not equate the current director of the FBI with what happened then by any means, nor his predecessors. But if you have some of that mindset in the name of fighting terrorism, and this has already happened, the government convinced a secret court that it needed to collect billions of phone records of innocent Americans, not because those phone records are relevant to any specific counterterrorism investigation, but rather because the NSA wanted to sift through them in the future. This is an extraordinarily broad reading of the statute. One that I can say is one who was here at the time the statute passed, Congress never intended, and the Second Circuit rightfully held that such an expansive concept of relevance is, quote, unprecedented and unwarranted. Also, such an interpretation of relevance has no logical limits. The debate is not just about phone records. If we accept the government can collect all of our phone records because it may want to sift through them someday to look for some possible connections to terrorists, where's it going to end? We know that for years the NSA collected metadata about billions of emails sent by innocent Americans, and they use that same justification. So should we allow the government to sweep up all our credit card records, all of our banking or our medical records, our firearms or ammunition purchases? How about everything we ever posted on Facebook or everything we've ever searched for on Google or any other search engine? Who wants to tell their constituents that they support putting all this information into government databases? I'd say enough is enough. And I do not accept that they will be very careful to make sure nothing happens to the secret data. So careful that they allowed a 20-something private contractor named Edward Snowden to walk away with all this material. What's to stop anybody else from doing exactly the same? During one of the 6 Judiciary Committee hearings I convened on these issues last Congress, 6 hearings, I asked the then Deputy Attorney General whether there was any limit to this interpretation of Section 215. I did not get a satisfactory answer. That is until the Second Circuit ruled last week, and they correctly laid out the implications of this theory. They said if the government is correct, it could use 215 to collect and store in bulk any other existing metadata, including metadata associated with financial records, medical records, electronic communications, including email and social media information relating to all Americans. I don't think you're going to find many Americans anywhere on the political spectrum that want to give this government or any other government that kind of power, because nothing under the government's interpretation would stop the government from collecting and storing in bulk any of these. Now, the potential significance of this interpretation is staggering. It's no wonder that you had groups as desperate as the ACLU and the National Rifle Association joined together to file the lawsuit in the Second Circuit to stop this bulk collection program. Now, Congress finally has the opportunity to make real reforms, not only to Section 215, but other parts of FISA that can be used to conduct bulk collection. Tomorrow, the House is going to consider the bipartisan USA Freedom Act of 2015. Senator Leahy and I have introduced an identical bill in the Senate. And if enacted, our bill and the House bill will be the most significant reform to government surveillance authorities since the USA PATRIOT Act was passed nearly 14 years ago. Because our bill ends NSA's bulk collection program under Section 215. It guarantees unprecedented transparency about government surveillance programs. It allows the FISA court to appoint an amicus to assist it in significant cases. It strengthens judicial review of the gag orders imposed on recipients of national security letters. The USA Freedom Act is actually a very common sense bill. That's why Senator Leahy and I were able to join together on it. And he's right. We come from different political philosophies, different parts of the country. Obviously, we don't agree on all things, but we agreed on this because it makes common sense and is something that should bring together Republicans and Democrats. It was crafted with significant input from privacy and civil liberty groups and the intelligence community and the technology industry. It has support from members of Congress, groups from across the political spectrum. In fact, I'd ask consent to editorials from the Washington Times, the Washington Post, USA Today, and the Los Angeles Times in support of this. The USA Freedom Act be included in the record.
Without objection.
And also a letter from the major technology industry companies and trade associations be included in the record.
Without objection.
Now, some would argue that no reforms are needed. Unfortunately, in these arguments, they don't go into what the facts, as the Second Circuit did. They invoke fear-mongering and dubious claims about the utility of the bulk collection programs to defend the status quo. These are the same arguments we heard last November when we were not even allowed to debate an earlier version of the USA Freedom Act because of a filibuster. Last week, some senators came to the floor to argue the NSA's bulk collection of phone records might have prevented 9/11. Now, this specter is always raised. It might have prevented 9/11 and been vital to national security. And we also heard that if we enacted this bill in the House and the Leahy bill, it would somehow return the intelligence community to pre-9/11 posture. Well, none of these claims can withstand the light of day. I'll go back to some of the facts, not just hypotheses, but let's deal with facts. Richard Clark was working in the Bush administration on September 11th. I asked him whether the NSA program we now have would have prevented those attacks. He testified that the government already had the information that could have prevented the attacks, but failed to properly share that information among federal agencies. Likewise, Senator Bob Graham, who investigated the September 11 attacks as head of the Senate Intelligence Committee, also debunked the notion that this bulk collection program would somehow have prevented the 9/11 attacks. And the NSA's bulk collection of phone records simply has not been vital to thwarting terrorist attacks. Now, when the NSA was embarrassed by the theft of all their information and the news about the NSA's phone metadata program first broke, well, they defended by saying that it helped thwart 54 terrorist attacks. Well, I convened public hearings on this. And under public scrutiny, that figure of 52, or 54 rather, initially shrunk to, well, maybe a dozen. We scrutinized that further. They said, well, maybe it was 2. Everybody realized that they have to tell the truth in these open hearings. Well, then they said maybe not 54, maybe it was 1. And that one example was not a terrorist attack that was thwarted. It was a material support conviction involving $8,000 and not a terrorist plot. And numerous independent experts also conclude the NSA's bulk collection program is not essential to national security. I mention these things, Mr. President, because it's so easy to come down and say, we are all going to face another 9/11. We're all going to face ISIS. We're all going to face these terrible attacks if we don't have this. And yet we can show that it hasn't stopped any of these things. The President's Review Group had former national security officials stated the bulk collection of Americans' phone records is not essential to preventing attacks. It could readily have been obtained in a timely manner using conventional orders. So, Mr. President, we can go with hysteria and overstatements, or we can go with facts. My state of Vermont, we kind of like facts. We shouldn't be swayed by fear-mongering. We shouldn't reauthorize, and we will not reauthorize the expiring provisions of the Patriot Act without enacting real reforms. When the House passes, and I ask 30 seconds more, when the House passes the USA Freedom Act tomorrow and sends it to the Senate, we should take it up immediately, pass that bill. The American people are counting us to take action. They didn't elect us to kick the can down the road or blindly rubber stamp intelligence activities that have now been found by the courts to be illegal. So I thank my good friend from Utah for yielding to me, and I totally agree with his position.